Single on a Saturday Night is brought to you by Patterson Law Firm, and we have Danyl S. Patterson here today to help us with some of our law needs. Well, you know, the slip and fall, it's raining out there, it's snowing out there, and a couple of people have fallen, and I was asked, well, somebody said I should shovel my walkway because people can actually sue when they slip and fall. Is that true?
That's a great question, Shelley. Actually, there is liability upon the homeowner if there's a slip and fall on their property. However, the law recognizes the impossibility of always instantaneously acting and responding. So here, take for example, in the city of Philadelphia, there is a 3-hour window from the time that the bad weather stops to the time that you actually have to have a pathway cleared. So that means, and it's kind of the assumption that out there, and if it's actively snowing and sleeting, that a person who is traversing a property would recognize there is a danger and that they need to be aware of that. Somewhat kind of assuming a little bit of the risk. However, once it's stopped snowing and people are traversing, you as a property owner have a responsibility to make sure that the path is clear. So in Philadelphia, 3 hours after any bad weather stops, inclement weather, you have to, if it's snow, you've got to shovel a 3-foot path. Remember that. People always think, oh, they just get out there and they just shovel a little bit. It's a 3-foot path. So think about it. 2 people side by side should be able to walk down your pathway. And you also have a responsibility to make sure that it has salted and not frozen over again. So that the law recognizes we can't all do everything instantly, but we've got to take some responsibility for the fact that we are property owners and look out for our fellow mankind.
Well, thanks, Danyl. That's great information because I really didn't take the responsibility and get out there because it was kind of cold and icy. But next time I will. And of course, car accidents. That's always a big issue. I was in a car accident and it was like a double hitter. I was hit by 2 people and I didn't know what to do. I didn't know who was responsible, but at the end of the day, I didn't do anything. So what would I have done in that situation? Because the second person was like, it's not my fault. He hit me. So what would I do?
Shelley, the law distinctly recognizes what we call two-tap accidents, and they're a little bit tricky. Now, we at the Patterson Law Firm understand the nuances of the law, and you as a layperson don't. In those instances, it's not about what the people who are in the accident say happened, it's what you can prove. So if you were the third person who was in line, so let's say you're at a stop sign and you were hit by one car that was hit by another car, and you as the person who's being struck can prove that you were tapped 2 distinctive times. It's what we call a two-tap accident, and both cars will be liable. So in this instance, the first vehicle, vehicle number 1, struck vehicle number 2, which then struck you, vehicle number 3. Okay, so you can prove that vehicle number 1 struck vehicle number 2, and that vehicle number and hit you, and that vehicle number 2 struck you. Two-tap accident. Therefore, both parties will be on the hook for you for any pain and suffering, damages, that's what we call them, that you have incurred. And what typically happens is we have experts, your medical providers will be able to show from diagnostic testing and from the symptomology that you have presented when you go to see them as to exactly which damages, which injuries you sustained as a result of each tap in the accident. That becomes key later on down the line, especially because each car has its own level of insurance. So let's take, for example, I know everybody sees the general and, safe auto minimum insurance required by law. Well, in Pennsylvania, the minimum is a 1530 policy, which means $15,000 per person with a total of $30,000 per accident. So if you're in a car by yourself and you're struck, that person is on the hook for a maximum $15,000. That's the maximum recovery. But if you've got 2 striking vehicles, you could recover $15,000 from car number 1 and $15,000 from car number 2 for your pain and suffering. And that's where it gets tricky, and that's why you want to make sure that you contact us at the Patterson Law Firm as soon as possible so that we can help you to navigate those insurance waters.
Wow, so if you have questions out there and you want to know more and you want to know more from the Patterson Law Firm, please go to Facebook and like Patterson Law Firm LLC right now, and then post your questions because she has the answers for you. I know I didn't get anything out of this accident. Nothing happened. The lawyer that I hired, I don't actually know what happened. I had real injuries. The doctor said so. I have proof, but my lawyer was not able to do it. So Patterson Law Firm, I am so glad you are a sponsor of Single on a Saturday Night. Patterson Law Firm on Facebook. And don't you have a website?
Oh, you can always contact me at our website at www.pattersonlegal.com. That's www.pattersonlegal.com. And if you need us right away, you can always call us 215-472-1833. That's 215-472-1833.
Thank you so much. We're going to get back to more Single on a Saturday Night.